what's extraordinary about this is that for a very long time, a number of UK NGOs were fighting against another bill. It was not law, it was a bill called the Draft Communications Bill and Charter. And what everybody was concerned about was that under this bill, the UK government was seeking greater powers to collect even more information and communications data about people. But what we learned with the Snowden revelations and the fallout from those revelations is that actually the UK government was already collecting this information because they relied on some secret interpretation of RIPA. And I think that Eric will talk to you a bit more about that and the litigation that came out of this. A number of other things that are required under the legality principles is that the law must contain a number of safeguards. So it's not enough to say you can have surveillance of operations for any offense. It has to be, the offenses have to be spelled out. The law must clearly indicate which categories of people may be subjected to surveillance and not mass surveillance, millions of people. It's specific targeted individuals. There must be strict procedures in place for ordering the examination, use and storage of the data obtained, and usually also their deletion. So there's really a range of measures, and the European Court of Human Rights in Strasbourg has been very clear about what these safeguards are. But unfortunately, in practice, we're far from getting there. So the second principle I wanted to briefly talk about is the one of judicial authorization. This is also a major principle to ensure that when surveillance operations being carried out, all the rights of the individual, their right to privacy, are put in the balance in the same way as national security concerns or the prevention of crime. Because, and what we see in practice is that, in fact, the decision to authorize surveillance operations is made by politicians or intelligence agencies. And of course, what's at the forefront of their mind is that they have to protect people. So there's very little incentive for them to take into account the right to privacy of the individual. So one of the key principles in here are that the surveillance operations must be authorized by a judge. And here we're going slightly further than established principles under human rights law, because the European Court of Human Rights hasn't quite recognized yet that judicial authorization is a requirement. It said that it's desirable, and it's been going towards, little by little, saying that it should actually be a requirement. And so together with other organizations such as EFF or Privacy International, we're pushing very hard for this to happen. But I'll stop here and let next speaker.
Thank you, Gabrielle. Now I want to give the word to Dr. Eric Metcalfe. He is a barrister, a lawyer in the UK, and is leading one of the key challenges against the GCHQ in United Kingdom. So, Eric, what you can tell us about your work in relation to transnational surveillance litigation, especially focused on today's theme workshop?
Well, first of all, thank you very much, Katitza. I'm very pleased to be here to be able to talk about this on behalf of EFF and Article 19. Just to be clear, I'm currently instructed by a number of human rights organizations in the United Kingdom and outside the United Kingdom in a claim which is being brought against the intelligence services in the UK. That's MI5, MI6, and but in particular, Government Communications Headquarters, or GCHQ as it's known for short. This was a claim that was first brought approximately 3 weeks after the Snowden revelations. So as soon as we had the information, we worked very hard to lodge a claim with a very mysterious body known as the Investigatory Powers Tribunal. This is a court, or a tribunal rather, in which you do not have a right to be heard, you do not have the right to cross-examine witnesses, You do not have the right to see the evidence on the other side. There's the tribunal that's been set up in the United Kingdom to adjudicate whether your human rights have been violated by disproportionate or unlawful surveillance by GCHQ, for example. And so after the Snowden revelations, Liberty, which is one of the leading human rights organizations, but also a number of other international organizations which it partners with, including the ACLU, the Irish Council for Civil Liberties, the Hungarian Civil Liberties Union, the Egyptian Centre for Personal Rights, and the Legal Resources Centre in South Africa, brought a joint claim saying that the use of bulk collection of communications and communications data in the United Kingdom was an unlawful and disproportionate interference in their right to privacy. And one of the key issues that this brings up is, of course, the issue of jurisdiction. Because it's very well for me to say, as a person in the United Kingdom, if the intelligence services in the United Kingdom violate my rights, I can go to court. But what is the issue when a person outside the United Kingdom has had their rights violated? And one of the key issues which was highlighted by the Snowden revelations is that the GCHQ has listening posts over a number of submarine cables, fibre optic cables, through which most of the world's communications and data is now transmitted, particularly on the transatlantic level, not only in the United Kingdom, but also in other points. We learnt about one recently in Oman, that GCHQ has a listening post which is sitting on top of submarine cables, carrying fibre optic communications data through the Middle Eastern cables. And the question becomes, if a government conducts this activity outside its own territory, or if you are outside the territory and that government violates your private communications, opens your envelope, reads your emails, listens to your telephone calls or your text messages, collects your communications data, what right do you have to be able to bring a challenge? So this is the fundamental issue of jurisdiction. Now, to anyone who's a scholar of international law in the room, I apologize, because what I'm about to give is an extremely crude version. But essentially, jurisdiction follows territory. You can bring a case, a country has jurisdiction or responsibility to safeguard the human rights of people within its jurisdiction, within its territory. But in certain circumstances, international law recognizes that jurisdiction goes beyond just where your borders are, but also to places where you have, for example, effective control. So I was involved in a case in 2007 about an Iraqi national who was being detained in southern Iraq by British forces. And in that case, the European Court of Human Rights held that the British government had effective control. No one said that the British government was responsible for Iraq, but certainly the British government had effective control in relation to that person. And so standing, as it were, to bring a human rights claim followed the degree of control that you have. But there's other principles which I won't bore you with. What I want to highlight is a couple of cases in the European Court of Human Rights where it's already recognized that it's possible to bring cases from people outside the borders. The first is a case called Weber and Saravia, against Germany. A couple of people who were from Uruguay, one of whom was a German national, complained that the German strategic monitoring program, which is a sort of a bulk collection program by the German government, interfered with their right to privacy, among other things. This was listening to telephone calls on a bulk basis. The complaint was dismissed for a different reason, but the European Court of Human Rights did not dismiss the complaint on the ground that the people were in Uruguay. They allowed they at least considered the complaint without dismissing it on the ground that they were outside Germany. In a second case, called Liberty and others against the United Kingdom, this was a previous case brought by the organisation that I'm representing, where Liberty, but also the Irish Council for Civil Liberties, brought complaints about the United Kingdom's bulk surveillance and complained about surveillance by the United Kingdom. And so, in our case, the current case that's before the Investigatory Powers Tribunal, we're looking at a situation where there has been extremely close cooperation between GCHQ and the NSA. And in particular, we're concerned that the NSA has, in some cases, collected exactly the same information as the British government would otherwise collect, and then given it to the British government. which then creates significant problems. Because what's the point in having laws regulating surveillance by your own intelligence services if your own intelligence service is friendly with a foreign government, which will then obtain the same information and then give it without the same legal regulations or restrictions? And so I think one of the fundamental features of the necessary and proportionate principles is that it seeks to address the legal issues that come about through transnational surveillance, because what we're finding is that in a world where counterterrorism cooperation and intelligence cooperation by governments is increasingly close and increasingly complex, and the ease with which communications may be intercepted and communications data can be retained and gathered simply by sitting on top of a fiber optic cable and gathering everything that goes through the pipeline, that we are seeing that governments now are able to share, I think with an unprecedented scope and ease, massive amounts of private information, not only the content of communications, but also what we call metadata, the location, the time, the duration, and so forth. And so the necessary and proportionate principles really provide a valuable bedrock in highlighting these issues. Thank you very much.
Thank you, Eric. I want to give the microphone now to Luis Fernando Garcia. He's Mexican. He worked for the NGO R3D, Red de Defensa de Derechos Digitales, with its name in Spanish. And I would like to ask Lee, what is your perspective from the Inter-American human rights systems on the extraterritorial application of human rights law, and what's the effect of countries like developed countries like Europe or the US are having in surveillance in Mexico?
Well, thank you, Katisa. Well, first, I would like to mention that this notion of extraterritorial jurisdiction and the extraterritorial application of human rights obligations has been not only recognized in the European, the case law of the European Court of Human Rights, but also recently by the Human Rights Committee in the concluding observations with regard to the United States, in which it clearly states that under the International Covenant of Civil and Political Rights, the United States has the obligation to safeguard privacy of all citizens, either outside or inside the United States. And based on this case law, on, for example, General Observation 31 of the ICCPR, so this is clear. No? And in the case of the Inter-American System of Human Rights, this is also the case. The Inter-American System of Human Rights, basically the Inter-American Commission of Human Rights, has established in several cases with regard, for example, to the United States and detained persons in Guantanamo, or the interception of Haitian refugees in high seas, or also recently in the interstate case between Colombia and Ecuador, that under the Article 1 of the American Convention and also of the American Declaration, the human rights obligations of the Inter-American System of Human Rights are applicable when states operate outside or its territory. The term jurisdiction is not, in the view of the Inter-American Commission of Human Rights, attached to a territorial aspect. And literally, what the Inter-American Commission has says is that the essence to determine whether, for example, whether the Inter-American human rights system bodies can judge the conduct of a state to determine international responsibility is if there's a causal nexus between extraterritorial conduct of the state and the alleged violation of rights and freedoms. In this respect, I think it's clear and uncontrovertible from a legal point of view that the actions, for example, that the United States is taking, surveilling foreign citizens outside and inside its country, it's unlawful. It's contrary to human rights obligations of the United States, and this is something that needs to be stated very clearly. It's unlawful, the actions of the United States surveilling other countries. But besides that, I'm interested in also mentioning what are the effects that transnational surveillance is having in different countries, especially in countries such as the one my organization works in, which is Mexico, and in other parts of Latin America. And I think there are also a question about what can or what should the governments of countries that are being surveilled by other countries should do, and it's their obligation to do to protect its citizens from this surveillance. And this is a tricky question. It's not really easy to respond. Some countries have thought of, for example, adopting some measures that can be regarded as counterproductive or costly or ineffective. And for example, the proposals of forced location of servers, of intermediaries in certain countries to have better regulatory control and try to protect privacy of citizens. But this, for example, the Inter-American Commission of Human Rights also in a recent report on freedom of expression on the internet mentioned these forced location provisions as costly and that can have an impact on freedom of expression that is contrary to obligations. Hopefully and thankfully, for example, the proposal that was put forward, especially by Brazil, was scrapped from the Marco Civil, and now it's not. It lost momentum, this idea, but it might come back, and this is we need to explore this. But there's this precedent that is regarded as contrary to human rights obligations. But there are other things that countries can and should do and are not doing. For example, in Mexico, no, the government of Mexico has just limited itself to make statements which lack credibility because then it don't follow actions. It just asks for clarifications by the U.S. government, but it hasn't realized that the actions and the surveillance that Mexican citizens have been subjected to, it's illegal. It's a crime inside of Mexico. For example, it was revealed thanks to the snow relations that, for example, the NSA has access to the data that is mandated to be retained by the law in Mexico on the servers of the telecommunication companies, and this raises questions, legal questions that are in R3D, the organization which I work for, is launching legal action in following weeks, where we're initiating different legal processes to make the people who might facilitate this surveillance accountable. Either U.S. agents that have operated in Mexico to access these data are committing crimes under the criminal code of Mexico, and also telecommunication companies should realize that their failure to protect its customers' data might also raise liability, either civil or criminal. And this is something that needs to be, that I think activists and lawyers, and we need to put our countries aware of, and to push for this accountability of U.S. agents inside our countries, and also of those who have facilitated this surveillance inside of countries. Thank you.
Thank you, Luis. I now want to give the microphone to Mr. Kent Roth. He worked for a cloud fair. He is a worldwide cloud provider. Kent, please. I have a question for you before you can do your own introduction. Can you give us the worm's eyes view how you deal with these cases where the government knock at your door?
Yes, absolutely. I guess first my remarks will focus on how human rights translate into consumer wants, and how Cloudflare as a company is working to be transparent, clear, and accessible in the spirit of these principles. When the government knocks at your door, it's very rarely in the middle of the night, and it's very rarely jackbooted thugs. They tend to be polite and respectful if you develop the appropriate rapport in advance. So let me rewind the tape a second. My name is Ken Carter. I run legal affairs, public policy, and government relations for Cloudflare. Cloudflare runs what's called a reverse proxy, which sits in front of our 2 million customers' websites to make them secure and performant. On a daily basis, we handle about 5% of World Wide Web requests. So the fear of bulk surveillance in the wake of the Snowden revelations has been a definite headwind to our business as individuals and companies fear bulk collection, and that as a US company that we are somehow enabling and facilitating this. That's not the least bit true. The sad irony is that data in the United States has greater protection from NSA and CIA type activities, but that doesn't mean that this doesn't create a headwind for our business. To that end, we've been doing several things, developing what we believe are best practices on what a corporate actor should be doing in this space. And I'd like to share with you sort of 5 guidelines for respecting customers' privacy internationally. First, privacy is a competitive advantage. If we offer better privacy protections for our customers, then we will be able to lure business away from our competitors. It is a selling point and a differentiating feature. So we aspire always to exceed any required thresholds. Second is disclose and adhere. Tell your customers what your practices are. What do we collect? How do we collect it? How long do we keep it? And what do we do with it? And we stick to those practices. We don't allow outside uses of our network and our customers' data. For example, we would never, ever turn over SSL encryption keys or our customers' encryption keys. And if we were asked to do so, we would fight in court like hell to prevent that. We will never install law enforcement software or other equipment in our network, nor allow that to happen. And we will not provide any law enforcement organization a content feed of our customers' content. And finally, we always notify the customer of a governmental request and give the customer notice and opportunity to respond to the request. Third, we are constructively difficult. We maintain a rigorous and unwavering commitment to process, procedure, and the due process of law. Fourth, we're not afraid to say no. So if something comes to us which does not adhere to the due process of law, we will reject it out of hand. And I will give you a recent example. Some months ago, we were threatened by an FBI attorney to serve on us a national security letter. And I informed the attorney that he could serve it on me, but our corporate policy is that we would litigate that letter, we would contest it in court, and we would exhaust all appellate remedies. So the FBI withdrew the request. It backed down. And then we blogged about it. To this end, also, don't be afraid to sue. There are organizations such as Katica's EFF that are happy to help even small companies like ours defend its rights and the rights of its customers. And finally, our 5th principle is educate your constituents. Educate your customers, educate your employees, educate your regulators, and educate the government officials who will bring you requests so that we can do this in an efficient way that doesn't waste their time, that doesn't waste our time, that doesn't involve going back and forth, when we can solve the problem in a more efficient manner. I welcome your questions, and I'm happy to tell the stories. Thank you.
Thank you, Ken. I would like now to give the microphone to Ms. Ravenna Rusik. She is the vice chair of the consultative committee set up under the Convention for the Protection of Individuals with regard to automatic processing of personal data. She also is the head of compliance department of the Republic of Serbia, office commissioner for the Data Protection Commissioner from Serbia. Nevena, I have a question for you. Oh, part of your speech. Would you like? Can you let us know, from your point of view of a data protection authority, and your experience with data protection, what data protection can do to protect governments against secret surveillance intelligence, or what it cannot do, or how Serbia is dealing with this request? Your unique experience. Thank you.
Thank you, Katica. Good morning, everybody. So I'm here also representing a consultative committee to the convention known as 108 on data protection at the Council of Europe, but also as a representative of a national data protection authority that is also dealing with transparency, which when it comes to intelligence services or state security services is very important, but they also need to be as transparent as possible. So when it comes to regimes, if I may, I would go back to questions that are posed in preparation of this workshop, like should we allow the intelligence services of one country to snoop on the residents of another without restraint? I mean, of course, the answer is of course not. And then can any country freely violate the rights of foreigners by claiming they fall outside their jurisdictions? Of course not. I mean, there's no free violation. Violation might be free, but has to be sanctioned. And the last one that I found a little bit more complex to answer is like, are existing surveillance laws compatible with the right to non-discrimination under international law? So, for example, when it comes to personal data protection under regime of the Council of Europe and the Data Protection Convention, the law being, I mean, the convention being an instrument for fulfillment of one's human right is applicable to each and every person. Conventions, especially when they're dealing with human rights, do not per se discriminate between foreigners or national residents. However, they may not be discrimination as such, but may be exclusion of the application of the convention to intelligence services or when it comes to national security issues. And that was possible under current convention, and many countries, not majority, luckily, but some countries as member states to the convention made the declaration that this particular convention was not applicable for national security agencies. That would mean that in that particular sense, when it comes to, for example, interception of communication, they would fall outside the scope of convention, and also the principles promoted and safeguarded by the convention. But it doesn't mean that different regimes would be applicable to national citizens or to foreign citizens, at least when we talk about Europe, because a person can claim that his or her rights have been infringed upon in front of European Court of Human Rights, and this is not related to citizenship. It is related to this national state that is a member state of the convention. So, for example, in Serbia, we don't have such an exclusion. There is no declaration made to the convention 108, and what applies to, for example, everyday use of personal data in private party relationships, it also applies to national security or intelligence services as well. So there is no different regime. What is peculiar with Serbia is that there is a very high constitutional standard when it comes to surveillance and when it comes to communication interception. So regardless whether that's for criminal investigation purposes or national security purposes, there has to be a court order. That's without any saying that there can be a different regime. And from the very beginning, both Information Commissioner and Ombudsman, and as well as other institutions, equated metadata with the interception of communication. So, and we actually were linking the stance with the European Court of Human Rights. Several decisions claiming that, for example, metering of one's communication is also a part of communication, and thus the regime should be the same. So we actually managed to have several laws providing access to so-called metadata, those retained data based only on the decision of a head of authority. In that particular case, it was military intelligence services and military security services, and also state intelligence services. So access to those data based on the order of the head of institution. Those legislations have been squashed by the Constitutional Court, and even for access to metadata, regardless of the procedure or the process against an individual. So no over collection of data. The individual has to be identified, or at least device has to be identified or identifiable. It has to be under court decision. When it comes to Council of Europe, just to switch back and give a little bit of European perspective, the new modernized convention that has been prepared by the consultative committee, and now it's under finalization of so-called ad hoc committee before being brought to the Council of Ministers of the Council of Europe, would not allow, well, at least this is the situation so far, would not allow any exceptions to the application of the convention. But that's a good news, because then it would mean that all the principles that are there enshrined in the convention and the rights of individuals would be applicable no matter what the field or activity of the state is in question. And at the same time, Venice Commission, that is also linked to Council of Europe, is preparing a report on intelligence service oversight. What is also not harmonized practice, let's put it that way, in Council of Europe countries, or in Council of Europe, but it is also applicable to European Union, is exactly this oversight. Who has the oversight over intelligence services? In some countries, like for example the Netherlands, or even Slovenia, I think UK as well, national data protection authorities, in fact in UK it's Information Commissioner, it's also in Slovenia, it's Agency for Data Protection in the Netherlands, are not competent for these agencies. So the supervision is excluded when it comes to security services or intelligence services. In some countries like mine, we are competent for each and every authority. I mean, whether it's good or bad, we don't know. But we had a case being competent also for that, and why I mentioned this transparency, which is also important, especially when it comes to interception. Several years ago, we had an information commissioner in Serbia, is also competent not only for data protection, but also for freedom of information, free access to information. So several years ago, we had an NGO requesting a state security agency to reveal the number of requested and approved requests for phone tapping. And they declared that was a secret. We were at the stance that that information should not be confidential and should be revealed to the public, because it's only statistic data. It's telling only about the number, not about the individual. The decision of commissioner was a binding, or is a binding one, and should be enforced. That did not happen. It was also confirmed by the administrative court. Nonetheless, the agency did not comply with the decision. So the case was brought to the European Court of Human Rights. It took a while for the European Court to decide, but that's the case in every case. And the European Court said it was not prescribed by law, because there was a clear decision that such information should be provided for. The decision of the European Court was not necessary, but especially because it's like a bad record for a country. But at the same time, it can be used as something positive, as a confirming standard that in this particular sense, although the European Court in this particular case did not go into depth and analyzing whether or not intelligence service should provide such data to the public, but there was a standard setting decision saying that this should be transparent. So the number of access or requests for phone or for communication interception should be known to the public, at least if we talk about number or statistics. So this can be also seen as a positive step supporting the principles that, like, transparency in that. And there are two the case that we are all eager to hear the results from. It's what was mentioned, so-called this Big Brother Watch case versus UK, and we will see what would be the court. First, actually, we would see whether it would pass admissibility test, and if so, what would be the result of that case. Yeah, that would be my contribution for now. Thank you.
Thank you. We have only 10 minutes left. I would like to ask if there is a question, remote moderator, for those who are monitoring the internet on the back. Yeah, not us yet. No? Yeah, please.
Hello. Can I be heard? Yeah. My name is Geeta Hariharan. I work with the Center for Internet and Society in India. I'd like to thank the panel for an open and frank discussion. But I'd like to say that statements that have been made at this panel are sort of wishful thinking. They don't reflect current law, but they reflect the law as it should be. We want privacy to be protected worldwide, and we want states to have we want human rights conventions to have extraterritorial applications. But the reality is that under present international human rights law, if we look at the scope clauses, the responsibility for states is either restricted to territorial boundaries, which can extend to citizens or non-citizens, or to those within jurisdiction. And the question here is what does jurisdiction mean? Now, Professor Harold Koh, in his two memos to the Obama administration, has said that you can extend jurisdiction to mean effective control over citizens abroad or non-citizens within your territory, or in other cases. So I think we've got to remember when we're discussing cross-border surveillance that in such a situation, it's very difficult to establish jurisdiction cross-border for a state like the US, which is conducting surveillance by the NSA. And this is the particular question that needs to be answered if we're looking for extraterritorial application of human rights conventions, because without extending the concept of jurisdiction to beyond territorial boundaries or beyond territorial effective control, such as Guantanamo Bay, it will be impossible to argue that there is a violation of privacy rights of non-citizens who are not within your territory or control. And those are the situations that we're considering here, unless we're looking at diplomatic or consular relations or a broader concept of territorial sovereignty and a violation of sovereignty under the United Nations Charter. So I think that if progress is to be made on considering whether human rights applications can be made non-territorially and to extend the concept of jurisdiction, this is the question that needs to be addressed. And I'd like the panel to consider whether legally this is possible to extend today. Thank you.
Eric.
Well, just to say thank you very much for your question, and I'd invite you to read the background paper, which actually we went into. It's not obviously an in-depth thesis, but quite a lot of detail into the relevant case law on jurisdiction. And one of the fundamental points to bear in mind is that you don't need to think necessarily about the fancy cases about extraterritorial jurisdiction. Start with the territory. The United Kingdom is scooping up the world's communications that pass through its fiber optic cables. Bring your case in the United Kingdom. My Egyptian clients, my clients in South Africa, my clients in Hungary, my clients in the United States have standing the British government has recognised that they have a right to bring their claim in the United Kingdom against the British government for surveillance of their emails, their internet, their text messages all over the world that the British government has gathered within the United Kingdom. Another point which is relevant, and this is particularly important for anyone within the European Union, think about where the data is being processed. This links back to the discussion we had about Serbian law. It doesn't matter, in a sense, where the data is being gathered. If the data is being processed within the European Union, then that is also a potential ground for argument. I can't answer the problems in the United States. You need a US lawyer. You need EFF to be on the case for that.
The United States does not follow international human rights law. Yeah. I think that the inter-American system could be a good answer to that, and the US have also signed, well, it's not technically part of the inter-American system, but it's part in some way. And Luis could talk a little about that.
I mean, the United States is not party of the American Convention of Human Rights, but it's party of the inter-American human rights system because it's part of the Organization of American States, and it has an obligation to comply with the American Declaration of Human Rights. And I think I disagree. I think the law is clear now, at least in the inter-American system of human rights. The concept of jurisdiction is not attached to territory, and it has even applied to the United States in several cases. And for example, the Human Rights Committee, which is the authorized interpreter of the ICCPR, a treaty in which the United States is party to, has established in its concluding observations regarding the compliance of the United States with the ICCPR that it has. I can show you my computer just shut off, but I was going to read a part of the concluding observations in which the Human Rights Committee explicitly establishes that the United States have to comply with the privacy rights of persons inside and outside the United States based on its surveillance. I think the legal question from the international human rights law perspective, another thing is whether the United States cares about international human rights law. That's another question. But from the international technical human rights law perspective, the actions of the United States are unlawful. I think from the inter-American human rights system view, and also from the interpretation of the ICCPR by the authorized interpreter of that treaty, which is the Human Rights Committee.
Just to complement that, the latest report from Nabi Pillai, the High Commission of Human Rights, also deal with the same issue. So there is a consensus about that. Yeah, if you want to, we are very happy. Which kind of law? Law at national level or international human rights law?
It is not law that you can go, for instance, to the ICJ or to the Human Rights Committee to be enforced. So, for instance, in the Human Rights Committee's concluding observations to the United States report in paragraph 22, they do not recognize that cross-border surveillance is unlawful. They don't say that. On the other hand, they say, in particular, under section 702 of the FISA Amendment Act conducted through PRISM and Upstream, we consider that this is an adverse impact on individual rights to privacy. And in paragraph 22b, they suggest that the United States should ensure that any interference with the right to privacy, family or home, etc., is authorized by laws. They do not outright say that it is unlawful. And when the Human Rights Committee does consider that certain acts are unlawful, they say so. They don't beat around the bush. So I'm not certain that this argument can be positively made. It is an argument that should be made, that the right to privacy is an erga omnes obligation, perhaps, is an argument that should be made. But I'm not certain that it is supported by law as it stands today. I'm happy to take this conversation outside.
Eric, do you have any comment?
Well, I mean, I'm just drawing attention to page 7 of the discussion paper, where you cite we cited a couple of decisions of the UN Human Rights Committee in 2 cases involving Uruguay, where it talks about the requirement under Article 2 of the ICCPR to respect and ensure covenant rights to all within the jurisdiction and all persons who may be within their territory and to all persons subject to their jurisdiction. This means that a state party must respect and ensure the rights laid down in the covenant to anyone within the power or effective control of that state party, even if not situated within the territory of that state party. Now, that's the Human Rights Committee's own jurisprudence in relation to, so it's not like it's a difficult concept, and then we've gone on to cite jurisprudence from the European Court of Human Rights, which is another major regional instrument. I think it's always fair to say in international law that you can, there's arguments always going to be made on both sides, but I don't think it is, you can simplistically reduce it to say it is only territory. As to the broader point about wishful thinking, well, with respect, no progress would ever be made in international law. We'd still be stuck with some 19th century concept of states' rights if we would never have an international human rights movement if people didn't stand up and make the argument that the law needs to develop beyond what it is. And we're already seeing with cases such as Digital Rights Ireland in the European Court of Justice, for example, where we're seeing courts breaking new ground in protecting and data protection rights. And recognizing that the retention, for example, of communications data of everyone in the European Union is a disproportionate measure. We're not saying that this is transforming international law overnight. It's identifying trends and it's identifying legal standards which are developing and it's hopefully laying out a blueprint for how that law will develop in future.
Thank you. One more question and we have to finish.
Hi, my name is Sinan. I'm from Turkey, and I speak for myself. I have a question to Kenneth Carter, to Cloudflare. Suppose that you receive a request from a country where you are not established, a request which is legal coming from the court of that country. What do you do? What will be your approach? Whether if it is in parallel with your policies or not, keeping in mind that if you do not comply, you may be banned in that country. I mean your services, and in the end you may lose money.
That's a fabulous question, and it highlights, it puts into clear focus the sort of problems that I deal with every day. It depends on the nature of the request. If it's a takedown under DMCA and they're asserting U.S. law, then we'll process it as a DMCA complaint, and that's really very straightforward. If it is a governmental complaint or in the context of some sort of civil or criminal litigation, we'll reject the complaint with a written response stating that you have an established jurisdiction over us. And then we will give the complainant the opportunity to reply or comply with MLAT or letter rogatory, and we do deal with the processes that come through the U.S. judicial system that way. But as you say, we can then be the subject of other kinds of retaliation. So it's not an easy thing to do, but it is the right thing to do.
We only have 1 hour and we want more questions, but we have to finish. So thank you so much for everyone who coming. We are organizing another event to go more deeper into this very complex topic that requires a lot of time. We're organizing in the Ungovernance Forum, which is a parallel event to the Governance Forum, when many civil society are getting together for 3 to 4 to discuss the strategies of how to deal with this issue. And then at 4, we have a whole panel discussion to try to find more ways of dealing with the problem. So you're invited if you want to go to the parallel IGF. Thank you.